Mr. Ostergren, how are you this morning?
I'm well. How are you?
Really good. Why don't you have a seat, and when you're ready, begin your opening remarks.
I will. Thank you. Good morning.
Morning.
When I saw that I was the 28th interview, it made me think of Mark Twain's quip about long meetings. And he said the problem with long meetings is very quickly in the meeting, everything has been said, but not everyone has said it yet. And so the meeting goes on and on far longer than it needs to go. So I'm sure you've heard a lot of very smart things from a lot of smart lawyers and judges about what makes a good Court of Appeals judge, and I'm sure I would agree with almost everything you've heard. What I'd like to do is dig right into my background and offer some reasons why being a county attorney is a really good preparation for being a Court of Appeals judge. I looked at the Court website, and the most recent statistics that are published on iowacourts.gov for caseload for the Court of Appeals are from 2017. You may have looked at them in preparation for this meeting. What those statistics show is just shy of 1,300 appeals disposed of by the Court of Appeals. And the breakdown was 36% criminal appeals, 13% post-conviction relief appeals, which technically are civil, but are criminal law issues tucked inside a civil case. So 49% of the docket criminal or quasi-criminal, and then 21% juvenile. So what that says to me, and I hope says to you, is the work of the Court of Appeals is 70% driven by cases that originate in a county attorney's office. Myself or one of my colleagues around the state has looked at a case and made a decision to file whether they're criminal charges or to defend a post-conviction relief action or to bring a juvenile delinquency or dependency case. And a certain number of those percolate up to an appeal disposed of by the Court of Appeals. So I would argue that the background of being a county attorney is about as good as you can get for preparation for what the Court of Appeals does. In particular, when we look at the court and the backgrounds of the judges on it, I would especially point to my experience in criminal law, and I think would be an excellent complement to the judges on the court and their experiences, because there's nobody currently on the court who has the kind of background that I do, having done criminal prosecution for 21 years, in addition to my other duties as county attorney. So with that, I'm looking forward to answering your questions.
Thank you very much. We'll start with, excuse me very much, Ms.
No question.
Oh, I think, let me look at my list here.
She's right.
Yeah, you're right.
No question at this time.
Okay.
Thank you.
No questions, thank you.
No question.
Mr. Diaz.
So, Mr. Ostergren, you and I had a conversation about your last appearance here,
Yes,
relating to the issue of the vehicle
yes.
that had been purchased through, not sure what they call the funds that were used, but I wanted to give you the opportunity to explain
Sure.
the relationship between you, the vehicle, and the county.
Sure, and I did ask my sheriff to fill in some of that with a letter. I hope that got through to everybody. So essentially, we in law enforcement, and specifically we in a multi-agency drug task force that we have in Muscatine, participate in certain forfeiture cases. I think that's the word you were looking for, forfeiture. And we buy, with proceeds of those forfeiture cases, things we need to continue law enforcement activities. Equipment like Nomex vests for the people who go in and raid a meth lab, computers, cell phones, vehicles, things of that nature. And so the vehicle was purchased as part of that and approved by that board as a law enforcement purchase. So that was sort of the relationship. So it's not directly by the county, it's by an agency that the county is a member of. It has a different board that governs how that drug task force is administered.
And you didn't require the approval of the county itself?
Correct, correct. There's an effort made to try and keep it away from, we don't want to take those dollars and go and pave streets with them or things like that. So it's administered separately.
Thank
Thank you.
Ms. Law?
No questions.
Mr. Bevel?
Yes. Mr. Ostergren, we talked, and I had a question about the case.
Sure.
Against the, city manager.
Right.
Is that case the federal case that's referred to in your application?
It is factually related to it. I mean, there was the underlying prosecution, and then it's factually related to it, yes.
Okay. And, well, two things. One, you say the case was dismissed when the insurance company paid the settlement.
Correct.
Did the policy have a retention, or was that all insurance company money? Because a lot of those policies, the county has a retention.
Right. Our deductible was $2,500, which goes against defense costs or any judgment that would be paid. And as you probably know, $2,500 goes pretty quick when you're responding to a lawsuit. So that was a sunk cost. And so practically speaking, it was all insurance company dollars.
Okay.
And so they make a business decision on that. It's out of our hands.
Okay. I don't have any other questions.
Mr. Sukup?
No questions.
Ms. Sinclair?
Have you ever considered applying to the district court? And if not, why not?
I have applied in the past, and I've decided that that's not a path I'm interested in anymore. I do love being a county attorney. I am very interested in the work of the appellate courts. I think just in terms of the personal satisfaction I get out of my career, I'm at a point where I love being a county attorney. I love being a lawyer. I think I would rather be a county attorney than a district court judge. I'd rather be an appellate court judge than a county attorney. And it's a complex decision to make personally. It has to do with the kind of work you get to do on the appellate courts versus the district court versus being a county attorney. And so that's just where I've ended up in that thought process.
Ms. Stigma?
Thank you. Mr. Ostergren, you obviously have a wealth of experience as a prosecutor. Can you please expand on the issue of being an advocate to being a neutral? With all of your years of prosecutorial experience, how do you then tell us as a commission that you're going to be able to step back from that and take on the role of a Court of Appeals judge who is not a prosecutor?
Sure. So it's a question that I thought I would get. And here's the best answer I can give you. If you're doing the job of a prosecutor correctly, when a case comes in to be evaluated, first of all, you need to start in a more neutral frame of mind. One of the things that sets apart what I do as a prosecutor is I don't have a private client for criminal justice purposes. Well, the county's my client for civil law things, but I don't have a client who comes in and tells me you have to file this charge, you have to seek prison. I get to exercise my own independent professional judgment when I look at a criminal case. And I take seriously the obligation that I have to the defendant, which is just as strong as the obligation I have to the victim or to society in general. I take seriously my obligation to not file charges if there's a question as to the suspect's guilt, or if there is a issue of admissibility of evidence. If I look at a file and I think we will lose a motion to suppress, I have a professional obligation to not file that charge, or to file a charge which would not depend on that evidence which is constitutionally suspect. And then when I go through that process, then eventually it's time to go to court, and then you flip on the advocate switch. You don't forget where you came from in that kind of neutral decision making, but then you go to court, you present evidence, and you argue your case, and you've turned on your advocate switch. If I make the transition to being a Court of Appeals judge, I get rid of the advocate switch. You never turn that on, because you're not going to court as a lawyer. You just stay in sort of your normal default mode of looking at a file and making an objective decision about it as best you can. So that's the best answer I can give you, is how I make that transition.
Thank you.
Mr. Goodman?
Thank you, Your Honor. I have two short questions and then one that might call for a longer question.
Okay.
Answer. How did you become the president, or past president of the Iowa County Attorneys Association?
So I was involved in the association as an assistant, primarily on the legislative committee. And then I did a 2-year term as an associate board member. So it's a non-voting board member when you're not an elected. And then once I got elected, one of my career goals was to run for the board and work my way up to being president. The County Attorneys Association works like a lot of professional organizations in that you run for secretary treasurer, and then it's a progression to be president. So you have a total of 4 years in that sequence, 3 to prepare for your year as president, and then your year as president. So it was essentially talking to my colleagues, and we did have a contested election for that, which I prevailed in. Our tradition is we never announce the vote total. It's a little bit of secrecy, I think, is better for collegial relations. So I don't know if I won by 1 vote or a lot more than 1. But I was elected by my peers, which I was very proud of, and then had that 4-year sequence to be president, and now serve as an active past president.
Okay. Just a couple other questions briefly. How many amicus curiae, amicus briefs have you written on behalf of the association on criminal matters?
Approximately a dozen.
Okay, fine. And then my final question is, if you were put on the Court of Appeals, do you believe that your role on the Court of Appeals, with your background in criminal law, would enhance the court? Or do you actually believe that there are times when, because of the makeup of the court, there are decisions made that relate to criminal matters where you think, well, that might have been the right decision, that more information is needed to be written in the opinion to give law enforcement guidance? Or are there even times where you say that outcome would have been different if I were on the court?
I think having a criminal law background is a critical component to all the backgrounds that it's going to take for a multi-member court to work effectively. And the background I have is not one that is currently represented on that court with its 7 current members, nor has it been represented on that court in recent history. I can't think of somebody who was a county attorney and then was appointed to the Court of Appeals. There are certainly Court of Appeals judges who worked as an assistant for a period of time early in a career, which would be valuable, but it's not quite the same as 2 decades plus in the trenches, so to speak, in criminal law. I think, I'm certainly not here to trash what the Court of Appeals does. They do, I think, a good job, really. They really do a good job. They get cases out pretty quickly, all things considered. I do think it's less a question of, when I read a slip opinion, do I think, did they get that result wrong? It's a question of, does this result raise other questions that we haven't thought of? And I'm going to give you just a really quick example. So last term, the Iowa Supreme Court decided a case called Anderson versus State, and it deals with post-conviction relief. It deals with the situation where somebody has started a collateral attack on an underlying criminal conviction, and then they lose, and they claim the reason they lost was their lawyer for their post-conviction relief claim was ineffective. And so in Anderson, the Supreme Court said, you can file a successive post-conviction relief claim, which is deemed to relate back to the first one if it is focused on effective assistance of post-conviction relief counsel. But you must do it promptly. The problem with the word prompt is it's really hard to enforce the word prompt. I can enforce 30 days, I can enforce 90 days. What's the word prompt mean? Now, there's been a series of Court of Appeals cases that assume that prompt means after you have lost your direct appeal of that first PCR, when proscendendo comes down, then you can file a successive PCR application. Well, that means 2.5 years later. Is that prompt? Next week, I'm presenting on this topic to the Bar Association Criminal Law Section CLE. And the problem is, you've got some Court of Appeals cases that just assume that it's after proscendendo. I don't think that's clear from Anderson. And if I had been on those panels, I would have said, wait a minute. We can't just assume without really briefing it and really digging through that prompt means after you've lost your direct appeal, or you get an order from a district court judge that says you lose, should you turn right around and file a successive PCR? If you go through and you win your appeal on the first one, then your successive one maybe becomes moot. That's a really nuanced technical, and I hate the fact my light turned yellow when I'm giving that long, detailed answer here. But when I look at that as a criminal law practitioner, I think, wait a minute, Court of Appeals, I mean, arguably that's dicta, but you're trying to decide something there that is not at all clear. And I think somebody with my background who litigates post-conviction relief cases sees that and says, wait a minute, stop. That's, we need to figure that out.
Thank you very much.
Mr. Bloom?
No questions, thank you.
Ms. Conover?
No questions, thank you.
Ms. Roberts? Ms. O'Brien?
Thank you. Mr. Ostergren, I read the Quad City Times, so your name is there frequently. So I have a question about a story from, I think, about a year ago, involving a raid of CBD oil retailers in Muscatine. Could you explain that situation and your role in it, please?
So I'll do so. I would need like a whole 20-minute session to explain the law of cannabidiol in Iowa. The bottom line is there's a whole medical CBD regulatory scheme that the state has put into place where you go get a card based on the doctor saying you have a certain condition and it's one of the conditions on a list, and you can go to a dispensary and get it. You've got other people selling CBD products just off the shelf, and there was a store there in Muscatine where the individual was sort of practicing medicine almost and prescribing, so to speak, these CBD products. And then what I said was, you can't do that. We didn't charge anybody. I could have frankly filed really serious criminal charges against some people, and I decided it was better to just say, look, you can't do that. We have a regulatory system for CBD products, and what you're doing is not legal. So I think it was really an example of using my discretion. I could have charged some people with some pretty heavy-duty drug trafficking felonies.
Were these products the same as what you see on the grocery store shelves now?
One of the problems is there's a lot of stuff on the shelves that's not what it purports to be on the label, so it's hard to answer that question. There's a lot of the CBD products that are actually totally counterfeit. As a subset, there's products that claim to be made from the marijuana plant. And if they are, if we send them to the state crime lab, the crime lab will identify them as marijuana. They're not legal. So it's a really complex area of the law, and what I was trying to do was tell people, hey, you can't, what you're doing is illegal. That's what the Board of Health says, that's what the Board of Pharmacy says, that's what Public Safety says, but without doing it by arresting people and charging them with serious felonies. So I'm sorry, I could talk about CBD for an hour.
Okay, thank you.
Mr. Horbach?
I'll pass to Mr. Gray.
Yes, Mr. Ostergren. Muscatine, I don't believe it's ever had a Court of Appeals judge. Do you believe that the judges on the Court of Appeals should be from diverse areas, and why?
I think it helps to have people who've practiced law in all the corners of the state. The last appellate court judge that Muscatine County had was before the Civil War, actually. In the history of the Court of Appeals, there's actually not been a judge on the court who practiced in the 7th Judicial District. So take that for what it means. I think it's good that you've practiced in small courthouses and medium courthouses. There's a lot of courthouses that are smaller than mine. Sometimes we feel pretty small. The 14th largest county in the state. I think having had, in addition, a variety of experiences in the practice of law, a variety of experiences in the kind of communities that you've worked in is really helpful. Sioux City is a little different than Muscatine, is different than Ottumwa, is different than Decorah, and having people from all over the place I think is good.
Thank you.
Thank you.
Thank you very much, Mr. Ostergren.
Thank you.
We appreciate your application and wish you the best of luck.
Thank you very much.
Thank you.